arrest or detention case, if you go to trial and you're found guilty, it's habitual. You're looking at 25 to life. We can set it for trial. I'm not playing games, and I'm not going to accept the disrespect. Good morning. Are you Victor Charles Campbell Jr.?
Yeah.
And Mr. Parker, will your client waive the formal reading of the indictment in each case?
Well, you are.
And it looks like we are going in 21-36426 and 22-39050, correct?
There's also a dismissal in 3-059.
Yikes. Full sarcasm from a bench. Now, legally speaking, the judge is explaining the difference between a repeat offender enhancement and a habitual offender enhancement, which absolutely matters for sentencing. But emotionally, this exchange has completely broken down into frustration on both sides. And here's what makes courtroom videos like this so gripping. It's not just law anymore. It's personalities colliding in real time.
All right, Mr. Campbell. In cause number 21-36426, you're charged with a third-degree felony offense of evading arrest or detention with the use of a vehicle, and that's from November 28th of 2020. The indictment further alleges that you were previously convicted of assault family violence, a third-degree felony, December 5th of 2014. And how do you plead to that charge? So to the charge, let's start with just evading arrest or detention with the use of a vehicle from November 28th of 2020. How do you plead to that charge? Guilty or not guilty? It's guilty or not guilty. Either you did it or you didn't do it.
I thought that's what the plea was.
There's a plea agreement means in my...
It might be the most uncomfortable moment of the entire hearing. The judge asks whether anyone forced him to plead guilty, which courts are legally required to confirm on the record. His response? I think you did. Now, realistically, the court is asking whether he was illegally coerced, not whether he felt pressure by the situation. But still, hearing that out loud in open court creates a moment where everybody watching suddenly questions whether this plea is truly voluntary. It's awkward, tense, and honestly kind of surreal.
My court, you either enter a plea of guilty or not guilty. Mr. Campbell, I understand that you're already doing time for a murder and that you don't really care about what's going on today.
I'm saying I'm pleading no content because he never even went over the indictment with me.
Yeah. I find that hard to believe. So here's the thing.
Actually, be honest, I just only been here for like about 30 days. So I got like 3 weeks or 30 days and about 2 weeks of being here.
Here's a picture of here.
Yeah.
So, the nature of the crime, no cause number.
And just like that, after all the arguing, interruptions, confusion, and tension, deal is done. 18 years on both cases, running concurrently with his existing sentence. One case dismissed as part of the agreement. Appeal rights waived. What's fascinating here is how this hearing became less about whether he would plead guilty and more about control, communication, and courtroom authority. I want to know what you think. Was the judge trying to keep order in a chaotic hearing, or did this situation escalate more than it needed to?
And the magistrate, as far as the indictment, I never received due to the fact of the nature of the charge being from 2018. You have 5 years, 4 years to actually send that indictment.
Sir, the allegation.
I'm pleading no contest.
I'm not going to allow.
It's fine.
Here's the thing. I don't have to accept any plea agreement. Okay. So you can in that evading arrest or detention case, if you go to trial, you're found guilty. It's habitual. It's habitual. 25 to life. We can set it for trial. I'm not playing games. I'm not going to accept the disrespect. If you want to follow this agreement and go along with the plea agreement, and you can go on, do your time and be done with it, then we can get that done. But you're not going to show disrespect while we're doing it. Do you understand? So if you want to go forward, we'll go forward. We'll set for trial, get ready very quickly, tried within a month. And it'll be...
And right away, the courtroom energy changes completely. The judge isn't just talking about prison time here. She's laying out leverage. In Texas, habitual offender enhancements can turn a serious case into a life-altering sentence fast. This is one of those moments where the courtroom stops feeling procedural and starts feeling like high-stakes negotiation under pressure. And you can already tell this defendant is not going to make this easy.
What do you want to do?
It's 18 years.
If you go to trial, listen to me. If you go to trial and you're found guilty and your prior convictions, stop talking over me. If you go to trial and you're found guilty and those prior felony convictions are true, then you're looking at habitual, 25 to life. Today, there's an agreement for something different. I'm glad to accept that if that's what you want to do. But you're going to either accept responsibility and plead guilty or plead not guilty. That's your choices. So let's go back then and cause number 21, 3.
Okay, pause for a second, because this is where things get legally interesting. The defendant keeps trying to enter a no contest plea, also called nolo contendere. A lot of people think that means kind of guilty, but not really. It doesn't. In criminal court, it usually carries almost the exact same punishment as a guilty plea. But here's the twist. Judges are not required to accept that plea in a negotiated deal. And this judge, she is making it crystal clear this courtroom is running on her terms. Question for you guys. Do you think the judge is being patient here or already losing patience?
6426. You're charged with a third-degree felony offense of evading arrest or detention with the use of a vehicle from November 28th of 2020. How do you plead to that charge? Guilty or not guilty?
That's what I'm saying. He's not stopping anybody. Evading arrest is guilty.
It's evading arrest or detention with the use. I'm looking at your indictment.
You're saying you got indicted for evading. In 2014, you were...
That line right there, that's the moment this hearing turns from tense to combustible. The judge is trying to maintain courtroom control, while the defendant keeps interrupting and challenging the process. And honestly, this is the kind of interaction that can dramatically affect how a judge perceives a defendant, even before sentencing is finalized. You can almost feel everyone in the courtroom realizing one wrong comment could completely derail this plea deal.